Yes, now can you hear me? Okay, sorry guys for the inconvenience. I don't know what was the issue, so I'll just share my screen and then we'll start. I'm really sorry. So just give me a second. I'll share my screen. There was something wrong with the system. Yeah, so I hope now it's clear. Okay, so I initially what I had stated that in last class we covered current affairs, or you can say landmark judgment from the month of February, and today we would be covering from the month of March and April. And you know that in every month there are lots of judgment which is given by different courts, but all the judgments are not that important from exam perspective. So we have to figure out that which all judgment can be important from exam perspective and what all we have to read. So you know that CLAT ka syllabus is totally, or you can say mainly focused on cases with respect to torts, cases with respect to contract, constitution, or for that matter, criminal law. So if you find something from these subjects, you can focus on that. Apart from these subjects, even if you find something important from other subjects as well, if it is having some link to the information what we have studied from constitution's perspective also, then that is important. Or if there's any landmark judgment which has changed or which is going to change how the law in country would be working, so from that perspective it is very important. So from March and April, I couldn't find much cases. Just there were 9 cases which I thought will be important from exam perspective. Otherwise, there were multiple cases which we all need not to study. So we'll talk about the first case, which is Rajat Sharma versus Union of India. Okay, so this case is again based on sedition. And in the first live session, I had discussed a lot about sedition, that which all cases shall amount to sedition, and what's the stand of Supreme Court, what's the stand of government, and when the court is going to decide about the constitutional validity of sedition. And we also discussed that this is the high time where the court shall decide, or court shall come up with the guidelines, or shall declare it as unconstitutional. So this is another case where one of the petitioners, he filed a plea against ex-CM of Jammu and Kashmir, Farooq Abdullah. So basically, he stated that Farooq Abdullah made a statement that will store, Jammu and Kashmir and will take help from China. So his petition stated that he is trying to give or he is trying to hand over Jammu and Kashmir to China, and this is a very much seditious remark, and government shall take the action against him, and the Supreme Court shall take action against him. So Supreme Court clearly stated that if you have a view which is different from the government, so each of your view can't be called a seditious statement. And sedition is what? In layman terminology, if you have to understand the concept, so sedition is nothing where you are trying to dethrone the government through illegal means, or where you are trying to create chaos in the society, or where you are doing something which is against the peace of the country. So that can be called as seditious. But if I'm not satisfied with what government is doing, or if I'm opining something on my own, or if I have a perspective, so that cannot be called as sedition. Similarly, if you criticize the action of government, so that can also can't be called as sedition. So this case is again talking about sedition. And here the court also imposed fine of 50K on Rajat Sharma, that you came to us without any ground and you wasted the time of court. So a fine of 50,000 was imposed on him. The second case is state of Rajasthan versus Love Kush Meena. Okay, so when we talk about this case is based on the basic principle of criminal law. So what are the two basic principle of criminal law? Can somebody tell me what you think that these are the two things or aspect which needs to be taken into consideration when we talk about criminal law, or when we deal with the issues whether a person has committed a crime or not? So what are the two important aspects which is being taken into consideration? Anyone would want to state what are those two aspects which are basic, you can say, tenets, or you can say basic feature of criminal law? actus reus artia is basically actus reus or mens rea, the important aspect which helps you in deciding that the crime, there has to have some act plus mental, intention attached to it. So that is, yeah, you can say that these two things are taken into consideration when you talk about whether a person has committed a crime or not. What I'm talking about is whenever you file a criminal complaints against anyone, the two aspect which court takes into consideration is, the first one is no one is guilty unless and until proven by court. The second one is you have to prove beyond reasonable doubt. So you can't say that you are a murderer or you are a, a thief, or for that matter you have done something wrong under or I mean under the offenses which is mentioned under IPC. You can't label a person unless and until court decide the same. Similarly, even if there's a single doubt in the mind of court can't hold a person liable. And the best example through which you can understand this is, you all must be aware of Salman Khan's hit and run case. So where Bombay High Court stated that, where Bombay High Court actually acquitted him, Bombay High Court stated that the prosecution couldn't prove his guilt beyond certain point, and still there's a doubt in the mind of, court, that who was driving the vehicle. So we can't hold him liable, and accordingly, the Bombay High Court acquitted him. After that, Maharashtra government stated that will go in appeal to, Supreme Court, but till now they haven't filed the appeal. So that is the one, I mean, two important aspect under criminal law. So in this case, state of Rajasthan versus Love Kush Meena, again the question was with respect to acquittal. So here Love Kush Meena, he got acquittal based on benefit of doubt in a very serious crime, and he, got selected in Rajasthan Police Services, and accordingly he asked for the appointment, and it was denied. So he moved to Rajasthan High Court, and Rajasthan High Court stated that since he has been acquitted, so let's give him the appointment. But then the government moved to the government moved to the Supreme Court, and Supreme Court stated that acquittal based on benefit of doubt in serious crime cannot make a candidate eligible for public employment. So even though he was acquitted, he wasn't acquitted on a very good terms, or court did not, said that, or court did not stated that, oh, you have not committed the crime. That was not in this case. So here the court stated that although he was acquitted and there was benefit of doubt, but it was a very serious crime and the prosecution couldn't prove it. But this doesn't state that, the person may or may not have committed the crime. So Supreme Court stated that on that basis you can't be given a appointment in public services, and that was denied. So Supreme Court basically overruled the judgment of Rajasthan High Court. Then the next case is Aparna Bhatt versus State of MP. So this is again based on gender, you can say equality, or you can say about genders training. So the Supreme Court has stated that you have to impart gender sensitization training to judges. So basically judges should be aware of, what are the issues which is related to gender, or for that matter you may also call it like with respect to women and all, and what all things needs to be taken into consideration. So the Supreme Court stated that gender sanitization training should be given to judges. In fact, the Supreme Court also stated that Bar Council of India shall take steps to include such courses as part of your LLB curriculum or AIB syllabus. So LLB curriculum is basically when you would be studying in law college. So they have stated that that should be included in your curriculum of 5-year course, and also in AIB exam. So when we say AIB exam, so you all must be knowing that once you pass out from law college, you have to clear All India Bar examination to practice as a lawyer. So the court has stated that it shall be included in that curriculum also. Then court has directed each high court to formulate modules on judicial sensitivity to sexual offences to be included or to be tested in judicial examination. So that module also shall be created by high court. So this is what has been stated in Aparna versus State of Madhya Pradesh. Then the next case is Mehra Bal Chikitsalaya Evam Navjot Shishu ICU versus Manoj Upadhyay. So in this case, the court basically stated that writ petition under Article 226 is not maintainable against order passed by State Consumer Commission. So in last video, we had discussed about the importance of Article 226 and Article 32, and when a person can approach the Supreme Court under Article 32, and when a person can approach High Court under Article 226. Also have stated that although Article 226 is there and there's no bar in approaching Supreme Court at first instant, but Supreme Court on various instances has suggested that first you shall move to High Court and then come to me. Similarly, in this case, the court has stated that when we talk about the hierarchy of consumer forum, so you have district consumer forum, then you have state consumer forum, and then you have national consumer forum. So then you are not satisfied with the judgment of state consumer forum, you shall approach to national consumer forum. There's an appellate mechanism which is available, which you shall avail instead of coming to High Court under Article 226. So the court stated that it is not maintainable and you shall go to the higher body which is there in the hierarchy. So that was basically that you shall go to National Consumer Forum instead of coming to us under 226. So this was decided by the Supreme Court. Then the next case is Sudarshan versus State of Odessa. So this case is talking about SLP. So you all must be knowing what is SLP. So this is something which is mentioned under Article 136 of the Constitution, which talks about special need petition, which is a discretionary power of Supreme Court. Supreme Court, if feels that the matter shall be entertained, they would be entertaining under SLP, or if they feel like that that's not important, they won't. And generally, where the question is with respect to interpretation of law, or where the question is with respect to constitutionality of law, or where the question is with respect to validity of law, so that will be taken into consideration under SLP. Court would not be taking into consideration your normal issues, or if you're not satisfied with the judgment of High Court, or for that matter, they won't be deciding your basic dispute. Here, the question is with respect, if there's a question with respect to law, then only court will take into consideration your review petition. So here the court stated that SLP filed only against review order of High Court is not maintainable. So basically, again, here the court discussed about the jurisdiction which is available to Supreme Court under SLP. And you all must be knowing the jurisdiction of court. So if you are not aware of what are the jurisdiction which is available to Supreme Court, so I would suggest you guys to go and read it. So for that, for example, you have to you should know what is original jurisdiction, what is appellate jurisdiction, what is advisory jurisdiction, each and everything you shall be knowing. Then you shall also know that whether original jurisdiction includes, or whether Supreme Court can decide matter with respect to water dispute between two states under original jurisdiction or not. And if not, then what is the concept of water tribunal, and what are the recent amendment which was proposed with respect to water tribunal. So you can just do a little bit of research, and if not, so in future classes, wherever there would be discussion with respect to water dispute, I would be covering that. But I want you guys to do a little bit of research so you can go and study on your own. Okay. Then the next case is Central Coalfield Limited versus Pardon Oran. I hope this is how you pronounce it. So here the court also discussed about compassionate employment. Okay, so why I added this case in this particular slide, where I found that this case may not be important from exam perspective, but it was discussing compassionate appointment and employment. And you guys must have seen or saw CLAT 2021 paper, where there was one passage based on compassionate appointment, which was the only passage which was related to current affairs. Rest of the topics were from static. And why it was related from current affairs? Because compassionate appointment is generally given to deceased family member and all. But now the court is, I mean, the government is also considering about giving it to family members on the ground of medical retirement. So if somebody seeks medical retirement at earlier age, so there it can be taken. Government may consider giving the appointment to his or her family member. So that's why you had a question, and that's why I have picked this case. So here the court stated that compassionate employment cannot be granted after a lapse of reasonable time period. So you all know that when you are approaching the court, there has to have a time period within which you can approach the court. If the dispute happened, let's say today, and I am deciding, or after 10 years, I'll wake up and I'll say that I'm going to court. So court won't take into consideration my petition. Court will say कि अभी तक कहाँ थे, you were sleeping, yeah. So that is something which is applicable in each and every case. So here also the court stated that there has to have a reasonable time period, and here the husband was missing since 2002, and then she filed a petition stating that her son shall be given appointment. So court stated बहुत time lapse हो गया है, and also the court stated that he went missing from 2002, but before that only he was removed from the companies, and accordingly this case is not fit for compassionate appointment. Okay. The next case is Faizan Batul versus Union of India and others. So this case is with respect to right to education. We all know right to education is a fundamental right mentioned in the Article 21A of the Constitution, but that is with respect to initial stage. That means till 14 years of age. Here the question was with respect to professional education. So the court stated that right to professional education, though not fundamental right, is not government largesse. That basically means that if you have come up with some, notifications, or if you have come up with some memorandum where you are stating that certain people would be getting certain, access to certain education, professional education, then you are bound to give it to such people. So here the case was with respect to, admission in medical college, and state has affirmative obligation to facilitate, you know access to education at all level. And court directed that Faizan, and there was this another petitioner Waziri, for direction to facilitate their admission in medical college in terms of policy and guidelines which was issued by the government of India, which was dated 9th April 2020, on allocation of Ladakh Central Pool seat in MBBS and BDS courses for 2021. So basically, government came up with a notification where they, provided or they fixed certain seats to Ladakh people, and then they denied admission. So the court stated that although it's not your right to professional education is not your fundamental right, but since state had stated something, they have come up with a notification, they are bound to provide admission, and accordingly these two people were asked to provide admission in medical college in Delhi. One was Maulana Azad, the other one was Lady Harding. Okay. The next case is Kerala Union of Working Journalists versus Union of India. Okay, so this case is talking about right to life. We all know that Article 21 is having wider scope and it covers every aspect. For example, Article 21 covers right to life, that also includes right to privacy, that includes right to pollution free environment, right to clean water. I mean, multiple aspects are included under Article 21. And here the court stated that the most precious article of fundamental right is right to life, and which unconditionally embraces even an under trial. So if somebody is in jail, he also has a right to, you can say, equality. You can't give them inhuman treatment. You have to, give them the treatment which they deserve. For example, I hope you all must have seen movie called Uddam Singh, which was recently released. So you must have seen the way he was kept in jail. You can't keep a person in jail like this at present time, because right to life plays a very important role. So here this person, he was sick. Medical treatment was needed. He was COVID positive. So the court stated that even though he is an under trial, and the bench was headed by Justice Ramanna, he stated that while directing to shift Kerala journalist from Mathura jail in UP to a government hospital in Delhi for medical treatment, because at that particular time, medical treatment was the first priority or first requirement which that person deserved. So accordingly, court stated that even though if he's an under trial, everybody has a right to life, and that is the most precious article, you can say, of fundamental rights. So this was decided in Kerala Union of Working Journalists versus Union of India. And the last case for today is Dr. Lakshmana Rao Patil versus CM and others. You all must be knowing this case. It is with respect to Maratha reservation, which the court struck down. So the constitutional bench basically decided this case. They had struck down the Maratha quota in excess of 50% ceiling limit as unconstitutional. So you know that the in case of reservation, it shall not exceed the 50% ceiling limit, and the Maratha quota was exceeding it, so Supreme Court struck it down. And the court stated that there was no exceptional circumstances which was justifying the grant of reservation to Marathas in excess of 50% ceiling limit as socially and economically backward class. The court also held by 3 is to 2 majority that 102nd constitutional amendment has abrogated the power of state to identify who all will fall within the category of socially and economically backward class people. Also, when I'm talking about 102nd constitutional amendment, the court is also going to decide about the constitutional validity of the same constitutional amendment. So you shall keep an eye on whenever the court is going to decide that. And the majority judgment also held that after introduction of Article 338B and 342A to the Constitution, the final say in regard to inclusion and exclusion of socially economically backward classes, firstly with the president, and thereafter in case of modification or exclusion from the list initially published with the parliament. So these are few cases which was important from the month of March and April. In coming session, we'll cover the cases from May and June, and subsequently we would be covering all the important judgments. So this was all from today's perspective. I hope I was of some help and you guys enjoyed it. See you in the next class. Thank you.